Ladies and gentlemen, could you take your seats, please? Our next speaker is Professor Stephen Waddams. Can you take your seats, please? Our next speaker is Professor Stephen Waddams, who comes to us from the University of Toronto Law School. Stephen Waddams was born 1942 in England and studied at the University of Toronto, studied later at King's College in Cambridge, where he received the Hearst Prize in Law. He joined the Faculty of Law at University of Toronto in 1968 as an assistant professor, and since then has been made a full professor in law. Prior to becoming a professor, he completed his legal education at the University of Toronto and at the University of Michigan Law School, where he obtained his master's and his SJD. Professor Waddams has lectured very extensively on the subject you're about to hear today, and he probably is best known because of his textbook on contracts, one of the leading works on contracts, which is published in 1977. He also has a casebook on contracts into its third edition, and he has a textbook on product liability into its second edition, which came out in 1980. In 1979, he published a book, The Introduction to the Study of Law. He has given one of these special lectures in the past on the law of torts, and of probably most interest to you, he is currently working on a new book which will deal with the subject at hand today, which is damages in the area of contracts. Stephen Waddams.
Thank you very much, Mr. Doran. I'm proposing in this lecture to deal with a number of separate areas in which there have been significant developments in the law of contract damages in the last 20 years. None of these affect the basic principle of compensatory damages, which, as Mr. Cherniak said earlier this morning, has remained unchanged, and that is that the party complaining, so far as it can be done by money, should be put in as good a position as he would have been in if the wrong had not been done. And in the contracts context, this means that the plaintiff is to be put in as good a position as he would have been in if the contract had been performed. The first topic that I shall deal with is the question of measurement of damages by reliance. By the normal rule of contract damages, as I just said, the party complaining is entitled to be put in as good a position, so far as money can do it, as though the contract had been performed. Where the plaintiff can show that he has made a profitable contract, therefore, the normal rule will afford full compensation. The plaintiff will not be entitled, in addition, to recover expenses incurred in reliance on the contract, because such expenses would have had to be incurred in any event in order to earn the promised performance. If, on the other hand, the contract was an unprofitable one to the plaintiff, his expenses may exceed the value of the defendant's expected performance. In such a case, it is not clear that the plaintiff ought to recover the full amount of his expenses. In a sense, the defendant's breach confers a benefit on the plaintiff, the benefit of releasing him from a losing bargain. If the plaintiff is to be put by the award of damages only into as good a position as he would have occupied had the contract been performed, this benefit ought to be taken into account. These questions arose in the English Court of Appeal in Anglia Television Limited against Reed. There, the defendant, who was an actor, had agreed to play a leading part in a television film to be produced by the plaintiff. The plaintiff had incurred expenses in preparation for production, some before the agreement was made with the defendant, some afterwards. On the defendant's repudiation of the contract, the plaintiff cancelled the production and abandoned the enterprise altogether. Application of the normal rule for measurement of contract damages would have required an assessment of the profits likely to have been made from the film had it not been cancelled. This was clearly at best a highly speculative inquiry. Further, there are facts that suggest that this movie probably would not have been a great commercial success. If it had been likely to succeed, one would have expected the plaintiff to have procured a substitute actor rather than to have abandoned the enterprise altogether. And Lord Denning's bald summary of the plot of the movie suggests that there was little prospect of a great artistic achievement. Here's what he said. Anglia Television Limited, the plaintiffs, were minded in 1968 to make a film of a play for television entitled The Man in the Wood. It portrayed an American man married to an English woman. The American has an adventure in an English wood. The film was to last for 90 minutes. The English Court of Appeal held that the plaintiff was entitled to elect to recover its expenses, including the pre-contract expenses, as an alternative to the normal measure of contract damages. One way of explaining the election would be to say that the plaintiff is entitled, if it wishes, to be put into as good a position as it was in before the contract was made. But this rationale would not explain recovery of the pre-contract expenses, which the plaintiff had already incurred before the defendant had undertaken any obligation at all. Lord Denning justified the recovery of the pre-contract expenses as follows. He, the defendant, must have contemplated, or at any rate it is reasonably to be imputed to him, that if he broke his contract, all that expenditure would be wasted, whether or not it was incurred before or after the contract. He must pay damages for all the expenditure so wasted and thrown away. This, however, does not seem fully convincing, for the conclusion that the pre-contract expense was wasted by the defendant's breach implies a supposition that had the defendant not broken his contract, the expense would not have been wasted. In other words, the presumption is that had the defendant performed his contract, the expenses, including the pre-contract expenses, would have been recovered in profits. And this, of course, was the very thing that the plaintiff failed to allege or prove. Nevertheless, the result of the case may be supported on the basis that in the absence of proof, one way or the other, of the profitability of the movie, it is to be assumed against the wrongdoer that the enterprise would at least have broken even, that is, that the expenses would at least have been covered by revenue. In my opinion, it is not unjust to make such a presumption against the defendant, who is, after all, the party in breach of contract. It would still be open on this approach for the defendant to prove, if he could, that the expenses would not have been recovered from revenues, and on proof of that fact, the defendant ought not to be liable to pay for the expenses. This view of the law is supported by a recent decision of the British Columbia Supreme Court in Boley Logging Limited and Domtar Limited, where a logging contract was terminated by the timber owner's breach. It was held that in principle, the logger could elect to claim its expenses, as in the Anglia Television case, but that if the owner could show that the logger would have incurred a loss on completion of the contract, nominal damages only should be awarded. Otherwise, the plaintiff would be put in a better position by recovering its expenses than it would have been in had the contract been fulfilled. Mr. Justice Berger said clearly that the plaintiff was not to be put in a better position than it would have occupied on full performance, and that the onus of showing the contract to be unprofitable was on the defendant. He said, if the law of contract were to move from compensating for the consequences of breach to compensating for the consequences of entering into contracts, the law would run contrary to the normal expectations of the world of commerce. The burden of risk would be shifted from the plaintiff to the defendant. The defendant would become the insurer of the plaintiff's enterprise. Moreover, the amount of the damages would increase not in relation to the gravity or consequences of the breach, but in relation to the inefficiency with which the plaintiff carried out the contract. The greater his expenses owing to inefficiency, the greater the damages. The fundamental principle upon which damages are measured under the law of contract is restitution in integrum. The principle contended for here by the plaintiff would entail the award of damages not to compensate the plaintiff, but to punish the defendant. So it has been argued that a defendant ought to be able to insist that the plaintiff's damages should not include any losses that would have been incurred if the contract had been fully performed. According to Tritle, and he quotes from Tritle's book on contract, it is uncertain whether the plaintiff can recover his entire expenses if those exceed the benefit which he would have derived from the contract had there been no breach. And then Mr. Justice Berger quotes from Ogus, his book on damages, it is not yet clear whether English law imposes this limitation. And Mr. Justice Berger continues, the tendency in American law is to impose such a limitation, and I think Canadian law ought to impose it too. The onus is on the defendant. And Mr. Justice Berger went on to hold that the onus had been met and that the plaintiff was therefore entitled only to nominal damages. So here the British Columbia Court has settled, as I think rightly, the point that was regarded as unsettled by the two English writers who were quoted. The second matter that I want to discuss today is the question of intangible losses caused by breach of contract. Until 1972, it was thought that no damages were available for mental distress caused by breach of contract. The case usually cited for this proposition was Addis and the Gramophone Company Limited, where the House of Lords rejected an award of damages to an employee for wrongful dismissal in respect of the harsh and humiliating way in which he was dismissed, including, presumably, the pain he experienced by reason, it is alleged, of the imputation upon him conveyed by the manner of his dismissal. In an action by a client against a solicitor, Lord Nenning said, it can be foreseen that there will be injured feelings, mental distress, anger and annoyance, but for none of these can damages be recovered. It was so held in Groom and Crocker on the same lines as Addis and the Gramophone Company. 6 years later, however, that's to say in 1972, in Jarvis and Swans Tours Limited, the same court, that's the English Court of Appeal, awarded damages against a travel agent, both for the loss of the expected enjoyment of the holiday promised and for the mental distress and disappointment caused by the breach of contract. Lord Denning said, what is the right way of assessing damages? It has often been said that on a breach of contract, damages cannot be given for mental distress. He cites some cases. The courts in those days only allowed the plaintiff to recover damages if he suffered physical inconvenience. But, Lord Denning says, I think that those limitations are out of date. In a proper case, damages for mental distress can be recovered in contract, just as damages for shock can be recovered for in tort. One such case is a contract for a holiday or any other contract to provide entertainment and enjoyment. If the contracting party breaks his contract, damages can be given for the disappointment, the distress, the upset and frustration caused by the breach. An obvious difficulty is how that sort of damage is to be measured. This, however, did not deter Lord Denning. He continued, I know that it is difficult to assess in terms of money, but it is not more difficult than the assessment which the courts have to make every day in personal injury cases for loss of amenities. In the Jarvis case, the price paid for the holiday had been £63, and the trial judge had given the plaintiff half his money back because, although he had cause to complain of the facilities that he found in Switzerland, he had enjoyed travel and accommodation there. So the trial judge thought about half the price was a proper award. Lord Denning assessed the damages as follows. Here's the whole of his reasoning on the damages question. Looking at the matter quite broadly, I think the damages in this case should be the sum of £125. As one commentator said, it seems rather generous to allow the plaintiff 100% profit on his disappointment. In a later case, Jackson and Horizon Holidays Limited, the English Court of Appeal reaffirmed the principle established in the Jarvis case. In Jackson, the plaintiff recovered damages not only for his own distress and disappointment, but for that of his wife and children. On the question of damage assessment, Lord Denning said, "Applying the principles to this case, I think that the figure of £1,100 was about right. It would, I think, have been excessive if it had been awarded only for the damages suffered by Mr. Jackson himself." And here I interject to make the point that Lord Denning was anxious to establish that there was a cause of action in respect of the wife and children's damages also. So he didn't want to say that this award could be upheld simply on the basis of compensating Mr. Jackson. He wanted to say it would be too much for Mr. Jackson, but just right for his wife and children also, so that he could also establish the principle relating to third-party beneficiaries in contracts, which we're not concerned with today, of course, whereby he could hold that there was a cause of action in respect of the damage to the wife and children. So he says it would have been excessive if it had been awarded only for the damage suffered by Mr. Jackson himself. But when extended to his wife and children, I do not think it is excessive. People look forward to a holiday. They expect the promises to be fulfilled. When it fails, they are greatly disappointed and upset. It is difficult to assess in terms of money, but it is the task of the judges to do the best they can. These cases have been applied several times in the Canadian courts. Subsequent cases have shown that the principle is by no means limited to cases of lost holidays, where peace of mind might be said to be the very thing bargained for. In Haywood and Wellers, the English Court of Appeal extended the doctrine to the case of a solicitor who failed in breach of contract to secure protection for a client against molestation. Lord Denning indicated that earlier decisions denying recovery for mental distress in actions by clients against solicitors might have to be reconsidered, though it should be noted, and the point was made in the case, that mental distress on the part of a client is more likely to be foreseeable where the solicitor is employed expressly to protect the client against molestation than in the case where the solicitor undertakes to convey land, say, or to prosecute litigation. Obviously, where the very purpose of the services is to protect the client from molestation from a man whose attentions were unwelcome, mental distress is obviously foreseeable if the solicitor bungles the job and fails to give the protection that he ought to give. But so one could distinguish other cases of solicitors' services, but I don't think it would be safe to assume that this doctrine won't be extended further against solicitors. Take, for example, the question of litigation. It's well known that litigation causes mental stress to the parties involved, and it seems to me that it could well be held to be within the contemplation of a reasonable solicitor that if he failed to conduct litigation properly, his client would be liable to suffer unnecessary mental distress. In Newell and C.P. Eyre Limited, Judge Borins applied the principle of the Jarvis case to the owner of pet dogs who were injured by breach of a contract of carriage. In Dunn and Disc Jockey Unlimited Company Limited, a small claims court judge awarded damages to compensate the plaintiff for the defendant's failure to supply entertainment at the plaintiff's wedding. In some cases, damages have been awarded for wrongful dismissal of employees. In a very recent Ontario case, Pilon and Peugeot Canada Limited, which has just been reported and was formerly the subject of a page 7 article in the Globe and Mail newspaper, an employee was wrongfully dismissed. The employee had served the company loyally for many years, and the company had led him to expect permanent security of employment. Because the plaintiff had mitigated his loss quite successfully, he was held to be entitled only to damages of about $1,000 in respect of the period for which he ought to have been given notice. Nevertheless, the Ontario High Court awarded damages for mental distress in the sum of $7,500, so 7 times the amount of the compensatory damages, 7.5 times. The case is interesting and significant, both in its application to employment contracts and in its departure from the comparatively modest level of damage awards manifested by previous cases on mental distress. It has been suggested by some writers that punitive considerations are entering the calculation of damages in these cases. Another possible explanation of the Pilon case is that the court intended to give compensation for the employee's expectation of some kind of permanence in the employment relationship, even though the court was unwilling to find anything like an enforceable contract whereby the employee had tenure or anything like it. A related matter concerns the question of injury to reputation. It was held by the House of Lords in Addison, the Gramophone Company, that damages for breach of an employment contract could not be enhanced by a claim for loss of reputation. Lord Atkinson said, "I can conceive of nothing more objectionable and embarrassing in litigation than trying, in effect, an action of libel or slander as a matter of aggravation in an action for illegal dismissal, the defendant being permitted, as he must in justice be permitted, to traverse the defamatory sense, rely on privilege, or raise every point which he could raise in an independent action brought for the alleged slander or libel itself." This conclusion has been accepted in several Canadian cases. In a British Columbia case, however, Tippett and International Typographical Union Local 226, the Supreme Court of British Columbia awarded damages against a union for injury to reputation caused to a member by wrongful expulsion in breach of contract. Since the rationale for excluding damages for loss of reputation appears to be basically one of procedural convenience, it seems unwise to rely on the exclusion of such damages as a firm rule in all cases. Well-established cases have awarded damages against banks that fail to honor a customer's check, causing loss of reputation, and in favor of actors for loss of expected advertisement. It seems, therefore, that there is no overwhelming difficulty in compensating injury to reputation caused by a breach of contract, where it appears to the court just and procedurally convenient to do so. It may well be, therefore, I would suggest, that future cases will lead to an erosion of this rule, just as the former rule denying damages for mental distress has been eroded. My next topic is of mitigation and anticipatory breach. The House of Lords held in a Scottish case, White and Carter Councils Limited against McGregor, that where one party repudiated a contract before the date of performance, the other party was entitled to ignore the repudiation. The House of Lords said, by a majority, that the innocent party had no duty to mitigate his loss. On the contrary, he was entitled to render an unwanted performance and to sue for the full agreed price. The Ontario Court of Appeal indicated in Finelli and D that this result would probably not be accepted in Ontario, and this indication has been much strengthened, in my opinion, by the decision of the Supreme Court of Canada, already referred to in an earlier lecture this morning, in Assamara Oil Company Limited and Sea Oil and General Corporation. This case involved a failure in breach of contract to return shares that had been deposited with the defendant. The shares increased greatly in value between the date of breach and the trial, and the issue was the date for damage assessment. The shares, in fact, were worth 29 cents at the time when they ought to have been returned, and subsequently it rose to a value of over $45. So you can see that a substantial sum of money turned on the question of the proper date for the assessment of damages. Although the problem of anticipatory breach was not directly an issue, Mr. Justice Esty referred to White and Carter Councils Limited against McGregor on the question of mitigation. He said this: "It is, of course, an eminently reasonable position to take if, as Lord Reid suggests in White and Carter Councils Limited and McGregor, in the case of anticipatory breach, there is a substantial and legitimate interest in looking to performance of a contractual obligation. So a plaintiff who has agreed to purchase a particular piece of real estate or a block of shares which represents control of a company, or has entered into a performance of his own obligations and where continued performance might aggravate his losses, might well have sustained the position that the issuance of a writ for specific performance would hold in abeyance the obligation to avoid or reduce losses by acquisition of replacement property. Yet even in these cases, the action for performance must be instituted and carried on with due diligence. This is but another application of the ordinary rule of mitigation, which insists that the injured party act reasonably in all of the circumstances. Where those circumstances reveal a substantial and legitimate interest in seeking performance as opposed to damages, then a plaintiff will be able to justify his inaction, and on failing in his plea for specific performance, might then recover losses which in other circumstances might be classified as avoidable and thus unrecoverable, but such is not the case here. It will be noted that Mr. Justice Esty interprets Lord Reed's speech as holding that the pursuer in White and Carter and McGregor had a substantial and legitimate interest in actually performing its contract, as opposed to mitigating its loss and seeking damages, and that the result of the case depended on this point. This reference of Lord Reed's to a substantial and legitimate interest is puzzling, because it is not clear how he applied it to the facts of the case, which involved a contract by the pursuer to advertise the defender's business by exhibiting metal plates on refuse containers. It is hard to see that the pursuer can have had a substantial and legitimate interest in preparing and exhibiting unwanted advertisements, rather than finding another advertiser and suing for damages if he could show that he had suffered any. However, it seems plain that the Supreme Court of Canada has held that a plaintiff can only be excused from mitigating his losses where he has such a substantial interest in actual performance as would justify the granting of a decree of specific performance. Thus, to take the Supreme Court of Canada's examples, a purchaser of a house need not normally look for a substitute on the vendor's repudiation, even on a rising market. He can insist on actual performance. But where the plaintiff's legitimate interest can be satisfied by substitute performance together with an action for damages, I would suggest that the Assamera case is authoritative for the proposition that he will not be entitled to hold the defendant liable for loss that could have been avoided by pursuit of this course, that is, by procuring a substitute and suing for damages. A second point related to mitigation concerns the plaintiff's lack of funds or impecuniosity. In two cases, the Ontario Court of Appeal has held that a plaintiff's damages were not to include loss caused by his own inability to mitigate due to lack of funds. In R.G. McLean Limited and Canadian Vickers Limited, the defendant had supplied a defective color printing machine. It was held that the buyer's damages were to be reduced because the seller had made an offer to refund the purchase price. In reply to the argument that the plaintiff did not have sufficient funds to purchase a substitute, Mr. Justice Arnott said, "The frailties, if any, of the plaintiff's credit or its inability to purchase a new press from available assets cannot be set up to destroy the effect of the defendant's offer." In Friedhoff and Pomelift Industries Limited, the plaintiff was the purchaser of a defective ski tow. He recovered his lost profits caused by the defect, but was denied recovery of loss caused by the collapse of his business. The court said of this loss, it does not meet the test of foreseeability. This last case, Friedhoff then, may be taken as holding that on the particular facts the loss claimed was too remote and doesn't seem necessarily to lay down any general rule that a plaintiff's impecuniosity is always, as a rule of law, to be ignored. Such a general rule has been specifically repudiated in several English cases, not cited by the Ontario Court of Appeal, curiously, because they were relied upon by the trial judge in Friedhoff and Pomelift Industries. In one of these cases, Lord Justice Denning, as he then was, said, "It was said that the damages were the result of the impecuniosity of the sellers, and that it was a rule of law that such damages are too remote. I do not think there is any such rule. In the case of a breach of contract, it depends whether the damages were reasonably foreseeable or not. In the present case, they clearly were." Though the case of Liesbosch Dredger and steamship Edison has been taken by some to lay down such a rule in tort, that case too can be explained as holding simply that the loss claimed there in that particular instance was held to be too remote. On principle, it is not clear that any sound reason supports a general rule excluding loss caused by the plaintiff's impecuniosity. In a decision of the House of Lords preceding the Liesbosch case, it had been said that a tortfeasor must take his victim as he finds him. Lord Collins had said, "And if the position of the plaintiff is aggravated because he is without the means of mitigating it, so much the worse for the wrongdoer, who has got to be answerable for the consequences flowing from his tortious act." This case was distinguished but not disapproved in the Liesbosch case. In view of the fact that the Ontario Court of Appeal in Friedhoff and Pomelift Industries Limited chose to give absence of foreseeability as the only reason for reducing damages and refrained from commenting on the English cases mentioned above, which, having been relied on by the trial judge, one supposes must have been in the mind of the court, It seems fair to conclude that the court did not intend to lay down a general rule that damages caused by impecuniosity are never recoverable. The third point related to mitigation that I want to deal with is the question of collateral gains. Where the plaintiff gains some benefit in the circumstances resulting from the defendant's breach of contract, the question arises whether the value of the benefit must be brought into account to reduce damages. This is one of the most difficult questions in the whole law of damages, on which the courts have been able to give very little guidance. It is said that collateral gains are not to be taken into account, but this is of little help in resolving the difficult cases, as it is evident that the gains are described as collateral in just those cases where the court has determined that they are not to be accounted for. The leading case is British Westinghouse Electric and Manufacturing Company against Underground Electric Railways Company of London Limited, where the defendant, having supplied defective machinery for the plaintiff's use, the plaintiff scrapped the machinery and installed new machinery that was much more profitable than the defendant's machinery would have been even if it had worked properly. In other words, the machinery purchased from the defendant was in effect obsolete, and the breach of contract provided the plaintiff with an opportunity to install much more efficient equipment. It was held that the damages recoverable from the defendant were to be reduced by the advantage to the plaintiff of installing the new machinery. Viscount Haldane put the matter as follows: the subsequent transaction, if to be taken into account, must be one arising out of the consequences of the breach and in the ordinary course of business. In Apico of Canada Limited and Windmill Place, the Supreme Court of Canada held that a landlord who, on the tenant's default, rented the premises to another tenant was not obliged to bring into account the rent received from the new tenant. In this case, the premises were in a building still half vacant, and the evidence showed that the new tenants would have taken another part of the building if the first tenant had not defaulted. The Supreme Court of Canada, adopting the statement of Viscount Haldane just quoted, described the second agreement as an independent transaction which in no way arose out of the consequences of the breach by the appellant. Though this passage does not make it obvious why the case differs from British Westinghouse, in my opinion, the distinction and the result are sound. In Apico, the Canadian case, the plaintiff would probably have rented other space to the second tenant even if the defendant had fulfilled its contract and occupied the premises in dispute. So, in that case, the plaintiff would have had two tenants instead of one. On the other hand, in British Westinghouse, the plaintiff was not a dealer in machinery. It could use only one set of machinery at a time, and consequently could not have profited from purchasing the new machinery without scrapping the old, a step that it would have found profitable even if the defendant had fulfilled the contract. Another problem that has recently exercised the courts in this context is whether in an action for wrongful dismissal, damages are to be reduced by unemployment insurance benefits received by the plaintiff. The argument in favor of reduction is that the benefits in fact reduce the plaintiff's loss. That's the argument that's always made in these collateral gain cases. If the plaintiff is paid for working, he has to account for his full income if the plaintiff gets a substitute job, for example. It seems anomalous that if he's paid for not working, as he is when he receives unemployment insurance benefits, he should not equally be bound to account. Against this is the argument that the wrongdoing employer ought not to benefit from unemployment insurance. The Supreme Court of Canada has recently, in Jack Sioux Limited and Jorgensen, endorsed this latter argument, holding that unemployment insurance benefits do not reduce damages recoverable from the employer. An ideal solution might seem to be to require the employee then to account to the Unemployment Insurance Commission for the benefits. In that way, the wrongdoer would not profit, the plaintiff would not be overcompensated, and the public purse would be relieved. It has been held, however, at the Provincial Court of Appeal level that the relevant provisions of the Unemployment Insurance Act do not permit this result in a wrongful dismissal case. The Supreme Court of Canada in Jorgensen expressly left this question open. Next, the date for the assessment of damages. In Asamera Company Limited and Sea Oil and General Corporation, the case I mentioned a few minutes ago having to do with the shares that increased so dramatically in value, the Supreme Court of Canada had to assess damages for failure to return shares. Millions of dollars depended on the choice of date for assessment of damages. The Supreme Court of Canada held that the plaintiff ought to have purchased substitute shares after a reasonable time. In view of the defendant's conduct, which delayed litigation, they held a reasonable time to be as long as 6 years. And the Supreme Court held that at this point, where a reasonable person would have purchased a substitute, damages crystallized and subsequent increases in value of the shares could no longer enhance the plaintiff's damages. Some other recent lines of cases seem to be inconsistent with this approach. One line of cases is that awarding damages to a purchaser of land where the vendor refuses to convey. It was held in Roth and Tyler, where the value of the land had risen dramatically between date of breach and date of judgment, that the plaintiff was entitled to damages measured by the judgment date value. In other words, the damages did not crystallize at an earlier point. Right up to trial, the damages could go on increasing, and the trial court assessed damages based on the then current value of the land to which the plaintiff was entitled. Though the House of Lords held in Johnson and Agnew that there was no distinction between equitable damages or damages in Ontario under Section 21 of the Judicature Act and damages of common law, the House did not disapprove of the actual result in Roth and Tyler. It should be noted, however, that Roth and Tyler was a case of the purchase of a residential house for personal use. The plaintiffs had invested their life savings in the purchase and were reasonably pursuing an action for specific performance, which they had reason to think would succeed. In other words, the plaintiffs could not be reasonably expected to have mitigated their loss by purchasing a substitute house. The very fact that we recognize it as a case for specific performance implies that we do not recognize a substitute as sufficient compensation. The facts were otherwise, however, in 306793 Ontario Limited and Rhymes, where vacant land was purchased for purely speculative reasons by a corporation described by the court as a shell company. The Ontario Court of Appeal followed Roth and Tyler without question, awarding the plaintiff judgment date value of the land and, moreover, refusing any allowance for interest on the purchase price that had been retained by the defendant. However, it may be suggested that it would not be unreasonable in the Rhymes case, which was the speculative purchase by the company, to hold that the plaintiff could have mitigated its loss by purchasing other land on the defendant's default, and that it would not be unjust to hold, as in Asamara, that the damages crystallized after the lapse of a reasonable time within which to effect a substitute purchase. Another line of cases that seems inconsistent with the Asamara case involves measurement of the defendant's liability for repair costs where these rise between the date of breach and judgment. In a tort case, the English Court of Appeal has recently held that the plaintiff, so long as he acts reasonably in delaying the repairs, is entitled to the judgment date cost of the repairs. This was Dodd Properties Limited and Canterbury City Council. And the same conclusion was reached in a contract case by the New Brunswick Appeal Division in Cormier Enterprises Limited and Costello. It is suggested that these cases are inconsistent with the fundamental principles of mitigation affirmed by the Supreme Court of Canada in Asamara. It seems to me to be undesirable to set up a rule, as these cases do, that gives the defendant an important interest in when the plaintiff effects the repairs without any power to compel the plaintiff actually to repair. It seems preferable to sever the relationship between litigating parties and not to create rules that are likely to distort the plaintiff's business decisions in order to enhance recoverable damages. In the absence of special circumstances, such as a justifiable claim for specific performance, in my opinion, the plaintiff in such a case is adequately compensated by an award of damages crystallized at the time when repairs could reasonably have been effected, plus interest to the date of judgment. A third line of cases is that dealing with obligations in foreign currency. Where a debt owed in foreign currency is paid and the domestic currency depreciates in terms of the foreign currency between the date of breach and the date of judgment, the situation is where a debt owed in foreign currency is not paid and the domestic currency depreciates in terms of the foreign currency between the date of breach and the date of judgment. Some courts have held that damages are to be measured at the date of judgment, or that judgment can actually be given in the foreign currency, which was the holding of the House of Lords in the Miliangos case. Either result is a departure from the notion that damages crystallize at or within a reasonable time of breach. The departure seems justified where, as is common, the plaintiff has no reasonable opportunity of mitigating his loss. But where he is a currency speculator, or is otherwise in a position to protect himself against the decline in the domestic currency, it seems that he is adequately compensated by an award of damages measured at the date when such a transaction could reasonably have been effected. Otherwise, he is enabled to speculate at the defendant's expense, claiming the breach date value of the debt where the domestic currency appreciates and the judgment date value where it depreciates. The rule laid down in the Assamera case is that damages crystallize within a reasonable time of breach, the reasonable time to depend on the plaintiff's opportunity to mitigate his loss in all the circumstances by effecting a substitute transaction. In my opinion, this rule is soundly based, and provided that interest is awarded at a realistic rate from the date of crystallization, this principle affords full compensation. Where the plaintiff has a legitimate claim for specific performance, as in Roth and Tyler, or for another reason has no reasonable opportunity to mitigate, as perhaps in some of the foreign currency cases, judgment date assessment of damages is appropriate. It is suggested that both the general rule of crystallization and judgment date assessment in the exceptional cases mentioned are fully consistent with the Assamera case and with basic principles of mitigation. A related point concerns allowance for inflation. In Leach Transport Limited and Neonex International Limited, the Ontario Court of Appeal recently held that in assessing damages for breach of contract, no allowance was to be made for inflation between date of breach and date of judgment. That is, if on ordinary principles of damage assessment, the defendant ought to have paid the plaintiff a sum of, say, $10,000 in 1975, the mere fact that judgment is not given until 1980, when the $1975 has depreciated, will not entitle the plaintiff to a larger sum. As the court pointed out, the normal recompense for being kept out of money is interest, and in inflationary times, interest rates reflect the expected decline in the value of money as well as the value of the use of money. Since 1977, as was also mentioned this morning in an earlier lecture, the Ontario courts have power to award prejudgment interest at bank rates, and this power equips the court with a workable means of protecting the plaintiff from inflation. So, in my opinion, the Ontario Court of Appeal is on sound ground in refusing to attempt to make a separate allowance for inflation. A few moments ago, I referred to cases dealing with foreign money obligations, and there have been some recent developments in this field in Ontario and other Canadian jurisdictions. It was, until the decision of the House of Lords in the Miliangos case, thought to be firmly established that obligations in foreign currency were to be converted into Canadian dollars at the date of breach, not at the date of judgment, still less at the date of actual payment. The consequence of this rule was that in the case of a declining domestic currency, a creditor owed money in foreign currency would recover fewer Canadian dollars than would be needed to effect repayment in the foreign currency. Because of the perceived unfairness and commercial inconvenience of this result, the House of Lords in Miliangos and George Frank Textiles Limited reversed the former rule and held that the English courts could actually give judgment in a foreign currency. In Canada, the question is complicated by Section 11 of the Currency and Exchange Act, which says that any statement as to money or money value in any indictment or legal proceeding shall be stated in the currency of Canada. In Batavia Times Publishing Company against Davis, Mr. Justice Carruthers, in a judgment affirmed by the Ontario Court of Appeal, held that he was bound by this provision to reject the conclusion reached by the House of Lords, and that he could not therefore give a judgment in foreign currency. He added that judgments in foreign currency would raise procedural and practical problems. However, Mr. Justice Carruthers accepted the argument that the conversion of the foreign obligation into Canadian dollars ought to take place at the date of judgment, not, as has been formally held on very high authority, at the date of breach. The earlier English breach date rule, which had been applied in 2 Supreme Court of Canada cases and by the Privy Council in a Canadian case, was rejected by Mr. Justice Carruthers, who said that although the Miliangos case in the House of Lords had not, of course, technically altered the law of Canada. Nevertheless, he felt that it was the duty of a trial judge in Canada to look not only to Canadian decisions, Supreme Court and Privy Council, but also to recent English developments, and that where he thought justice required him to follow the recent English developments, he should be free to do so, notwithstanding earlier Canadian authority. In Gross and Marble Office Manufacturing Limited, Mr. Justice Corey, while conceding that final judgment would have to be expressed in Canadian currency, permitted the issue of a specially endorsed writ for a sum expressed in United States dollars. And in Airtemp Corporation and Chrysler Airtemp Canada Limited, Mr. Justice Montgomery, applying the Batavia Times case, also sanctioned a departure from the breach date rule, converting the foreign obligation into Canadian currency at the date of issue of a specially endorsed writ, as being the latest practicable date in the case before him. A different view was taken by Mr. Justice Kirk Smith in the British Columbia Supreme Court, who reluctantly considered himself bound to apply the Old English rule, even though he admitted it had become obsolete in England. But he said it had become the law of Canada and nothing could change it but higher Canadian authority. However, in the later British Columbia case of William and Glynn's Bank Limited and Belkin Packaging Limited, Mr. Justice Mackenzie cited the Miliangos and the Batavia Times cases with approval and applied the judgment date rule of conversion of foreign currency into Canadian dollars. The present position seems to be then, particularly in Ontario, where the Court of Appeal has affirmed Mr. Justice Carruthers' judgment in the Batavia Times case, though without discussion of this issue, that the weight of authority is in favor of a power to convert the currency at the date of judgment, but not of a power actually to give judgment in foreign currency. The question cannot be regarded as settled, however. The considerations of fairness and convenience that moved the House of Lords in Miliangos to protect the foreign creditor are equally applicable in Canada, though, as suggested above, where the plaintiff is in a position to protect himself by mitigation, for example, if the plaintiff is a currency speculator, adequate compensation can be afforded by awarding the amount due at the date of breach plus interest. The wording of Section 11 of the Currency and Exchange Act, which talks about indictments and legal proceedings, does not specifically refer to the currency of judgments. Even assuming that it is correctly interpreted to require judgments to be expressed in Canadian dollars, and that it is within the powers of Parliament to enact, which has also been doubted, it does not, it would seem, require judgment to be expressed as a fixed sum. And so, in my opinion, it would not preclude a judgment requiring the defendant to pay such a sum in Canadian dollars as should be equivalent to a named sum in foreign currency at the date of actual payment. Procedural difficulties, such as the need to determine a fixed sum for execution or for rules governing set-offs, counterclaims, and payments into court, have not proved insuperable in England. And so I would suggest that we may yet reach in Canada a position equivalent in effect to that reached by the House of Lords in the Miliangos case.